Dear students, viewers and the subscribers, welcome to the IAS Mentor. You are watching lecture number 90 in the series Indian Polity, and the objective of this series, as I have stated many times, is to provide a comprehensive idea on the subject Indian Polity, and I am very sure that it is going to be extremely useful to the students preparing for UPSC and also other competitive examinations. Now we have covered almost 89 lectures. We are trying to cover each and every topic so that it is going to be extremely beneficial. And presently we are covering the topic of state legislature. As I already said, most of the things that I am going to discuss under the state legislature was already discussed as a part of the union legislature, because between the provisions of state legislature and the union legislature there is almost 90% overlap, but it is not completely the same. It is not identical. There are few differences in certain areas, so students should also be aware of what are the differences in terms of the constitutional provisions when it comes to parliament and state legislature. That's exactly what we are going to discuss, and that is exactly what we are doing. So today I am going to discuss about the law making process in the state legislature. Already we have discussed this elaborately when it comes to the parliament, but today we will see what are the differences in terms of law making process. First of all, we will try to understand as to what are the different types of bills, as to how the bills are classified when it comes to the state legislature, and how the procedure is little different when it comes to the law is made in the state legislature. And the most notable difference is, in case of an ordinary bill, when it comes to the parliament, both the houses have got equal powers. That is, both Lok Sabha and Rajya Sabha has got equal powers. But whereas when it comes to an ordinary bill, in case of the state legislature, if at all the state legislature is having two houses, that is legislative assembly and legislative council, the council does not have equal powers. Who is having more powers is only the legislative assembly. So what are the powers that is exercised by the legislative council when it comes to an ordinary bill, and also in relation to the other types of bills, we will try to understand in this particular lecture. And as a closing remarks of this particular lecture, I will also compare the powers between the legislative assembly and legislative council. That's again a very important area where UPSC asks certain questions in their examination. Alright, so with that we will try to understand how the bills get enacted in the houses of the state legislature. Before I proceed to that, first thing that we want to discuss is what are the different types of bills in the state legislature. As I already said, the different types of bills, how they can be classified. One way of classifying the different types of bills is based on the subject matter of the bill. Another way of classifying the bills is depending upon who is introducing that particular bill in the state legislature. So depending upon who is introducing the bill can be classified into what is called as a government bill, and it can also be classified what is called as a private member bill. So what is a government bill? A government bill is something which is introduced by a minister. If any minister is introducing a bill in the houses of the state legislature, then that is called as a government bill. But suppose if a private member is introducing a bill, then that is a private member bill. So who is a private member? Anyone who is not a minister. Anyone but not a minister is a private member. When I say anyone, anyone who is a member of state legislature, be it a member of legislative assembly or a legislative council, it does not matter, but he or she should not be a minister. So therefore students usually have a misunderstanding. A private member is someone who is from the opposition party. No, that private member can be from the ruling party or opposition party, but not a minister. If they introduce a bill, then that's a private member bill. Now depending upon the subject matter of the bill, subject matter means what exactly the bill deals with. Now depending upon the subject matter of the bill can be classified into three types when it comes to the state legislature. So how they can be classified? One, majorly it can be classified into what is called as financial bills. And second, it can be classified into what is called as ordinary bills. These are the two major classification, but I said it is three classification because the financial bills can be further classified into different types. So majorly it is only two types, financial bills and the ordinary bills. And there is one more classification when it comes to the bills that can be introduced in the parliament, which is also called as a constitutional amendment bill. But in case of the state legislature, the constitutional amendment bill cannot be introduced. So therefore, a constitutional amendment bill is not something which can be introduced in the state legislature. You can introduce either a financial bill or an ordinary bill, where the financial bill can be further classified into three types, which is money bill, or you have financial bill type 1, or you have financial bill type 2. So these are the classification of bills that you may have to keep in your mind when it comes to the state legislature. Now, what is a bill? A bill is nothing but a legislative proposal which is introduced in the legislative body, and a bill has to go through a series of steps in the legislative body as per the provisions of the constitution, as per the rules of the house. It goes through a series of steps, and then finally when it is approved by the houses, that in case if there are two houses in the state legislature, then it will go for the governor for his assent. And the moment it goes for the governor for his assent, and then the governor can exercise multiple options, as we already discussed under article 200 of the constitution. So if you look into the topic of governor, I already discussed as to what are all the options in the hands of the governor when a bill is presented to the governor for his assent. So you may refer to the previous videos also. But however, the students who are watching this video directly, I will also let you understand as to what the governor can do whenever a bill is presented to him. But however, as I already said a number of times to the students, to get a maximum benefit out of this particular series, you should watch the lectures in a chronological order. The moment you are going to watch the lectures in a chronological order, it is going to be extremely useful to the students. So try to watch it in a chronological order, especially when you are doing your first attempt, or especially when you are preparing for the first time, or you are making a fresh preparation. For those students who already spent certain years, you can pick and choose. Probably you can look into the areas where you do not have a conceptual clarity. But for the fresh years, you try to do it from the very beginning. All right. So what is a bill? A bill is a legislative proposal which is introduced in the houses of the state legislature. It goes through a series of steps in the both houses of the state legislature, and then it goes to the governor for his assent. And the governor can exercise multiple options. But if the governor gives the assent, then the bill becomes an act. And once a bill becomes an act, it can be enforced in a court of law. It cannot be enforced unless and until it is given assent by the governor in that particular state. So therefore, we will try to understand in the process of how a bill becomes an act as to what are all the various options that can be exercised by the governor. But however, one thing that you have to remember is the procedure for different types of bills. I said that depending upon the subject matter, the bills can be classified into different types. So the procedure for different types of bills are not going to be the same. The procedure for different types of bills are going to be little different. So you'll also try to understand as to what is the procedure for different types of bills. Okay. So first what we are going to understand is, we are going to understand as to what is the procedure for an ordinary bill. So once we understand the procedure for an ordinary bill, then we will compare the procedure for the other types of bills. And we will also try to understand as to what is the power in the hands of legislative assembly and legislative council when it comes to an ordinary bill. So these are all some of the things we will understand in today's lecture. But before I go to that, it should be very clear in your mind, a bill cannot be enforced in a court of law. A bill has no legal sanctions unless and until a bill is given assent by the governor in case of the states. And after the assent is given by the governor, then the bill becomes an act, and then they may have legal sanctions. Then only it creates obligations upon the citizens, and then only the citizens can also exercise the rights, if at all the bill confers some rights, the act confers some rights upon them. Alright, so what is the stage of enactment? What is the procedure to enact the bill when it comes to an ordinary bill in the state legislature? Assuming that the house is having what is called as assuming that the state legislature is having two houses. If the state legislature is not having two houses, what should be definitely be there in part of the state legislature is the legislative assembly. Every state should have a legislative assembly, but whether to have a legislative council or not have a legislative council depends upon the resolution passed by the legislative assembly of that particular state, and thereafter a law is made by the parliament. So suppose let us assume that a state legislature is having two houses. In that case, the bill can be introduced in either of the houses when it comes to an ordinary bill. Where the bill can be introduced? Any member of parliament can introduce a bill. It can be a minister or it can be a private member. It does not matter. So when it comes to an ordinary bill, remember the procedure is, it can be introduced by a minister or it can be introduced by a private member. It can be introduced either in the Legislative Assembly or in the Legislative Council. And before introducing the bill, there is no need to take the prior permission of the president. The prior recommendation of the president is not required in case of an ordinary bill. So once a bill is introduced, that is basically what is called as the introduction stage. So what happens in the introduction stage? The major objectives and reasons are discussed, nothing more than that. The major objectives and reasons are discussed. That means what is the very reason as to why this bill is introduced? What is the purpose it wanted to serve? So the person who introduces a bill give a broader discussion on this particular matter surrounding the objectives and reasons. And then once that stage is over, then the bill is referred to the departmentally related standing committees, DRSCs. Department related standing committees or appropriate committees in the state legislature. So basically department related standing committees are there in parliament, but similar committees are also there in the state legislature. So depending upon the subject matter of the bill will be referred to an appropriate committee in the state legislature. So then it goes to the appropriate committee similar to that of DRSCs. So the committee will scrutinize this particular bill and help the help the state legislature in arriving at a decision. So the very purpose of referring the bills to the committees is the committees having small members, it will help them to scrutinize the bills effectively, and whatever is their observation, they can prepare a report, put it in the form of a written, form, and then subsequently present the report in the house in which the bill is introduced, which helps the house in actually arriving at a decision on this particular bill. So the next stage is referral to DRSCs. The DRSCs or any appropriate committees, and they may take the time, they scrutinize and they again submit the report back to the house in which it is introduced. Suppose let us assume the bill is introduced in the state legislative assembly. So from the assembly after the introduction, it will refer to the appropriate committees, and the committees will scrutinize, give the report back to the legislative assembly. Now the next stage for the bill is discussion stage or the second reading stage. So what do you understand by discussion stage or the second reading stage? This is a stage where the house in which the bill is introduced will take up the discussion of the bill. So in the introduction stage, only the member will give a speech, and then the next stage is referral to the appropriate committees, where the committees will study. After they submit the report back to the house, in the second reading stage, the entire house in which the bill is introduced, they will take up the bill for discussion. They will go through the complete analysis of that particular bill, and if at all they wanted to make any changes in any provisions of the bill, that is likely to happen only in this particular stage. Suppose if they want to delete some sections, suppose if they wanted to add new sections, which is different from that, the way the bill is introduced in the house. So all those changes or any of the amendments is likely to happen only in this particular stage. So try to understand when the bill, which is a stage where the bill can be changed is only in this particular stage. All right. So after whatever changes they wanted to make, then the bill goes to the next stage in the house which is introduced. That is the example that you have taken is legislative assembly. Then it goes to what is called as the final vote or the third reading stage. So what happens in the final vote or the third reading stage? This is a stage where the bill is finally put to vote. Here no changes can be made to the bill. There are only two options that can happen in the third reading or the final vote stage. Either the bill can be totally accepted or either the bill can be totally rejected. If the house totally accepts it, then the bill is sent to the next house. If the house totally rejects it, then the bill becomes dead there. So therefore the bill cannot proceed further. So it depends upon what is being decided, whether they accept it or whether they reject it. It can either proceed to the next house or it will not proceed to the next house. Suppose if the bill is a government bill, normally if it is introduced by a minister, it is most likely the bill will be accepted in the third reading stage, because anyways the government already has a majority in the house. Suppose if the bill is a private member bill, introduced by a private member, it is very unlikely the bill will be accepted in the third reading stage, because it is not the agenda of the government, and any private member may not have support in the house. So therefore government bill, it is very likely to be passed in the third reading stage. Okay. Suppose if the bill is accepted in the third reading stage in the legislative assembly, assuming that the bill is introduced in the legislative assembly, then the bill is introduced in the next house. The second house is the legislative council. So suppose let us assume the bill goes to the legislative council. So when the bill goes to the legislative council, which is the second house in this particular case, then in the second house also the bill goes through the same process. So in the second house also there is an introduction, then it goes to what is called as second reading stage, third reading stage, and then in the second house also, after it is passed, then it will go to the governor for the assent. So once it is passed in the first house, the bill goes to what is called as the second house. So in the second house, what are the things that is likely to happen? We'll try to discuss. But assuming that everything is completed in the second house, and then the last stage is it is sent to the governor for his assent. And then the governor can exercise multiple options. So now let us try to understand first what happens in the second house. And then after what happened in the second house, if it goes to the governor, what are all the options that can be exercised by the governor? So we'll try to understand all those things. So try to understand and try to observe each and every single word that I am stating, because it is going to be extremely useful that each and every single word should be understood. So to have a clarity on what may happen in the second house. So what you have assumed is that the bill is introduced in the legislative assembly. Now it is coming to the legislative council. So when it comes to the council, in the council also the following things can happen. So what can happen in the council? First listen to me, then I'll write it down. So what can happen in the council? In the council also try to understand, in the council it is very much possible that it is introduced in the council, and after it is introduced in the council, then it will go to the second reading stage. In the second reading stage in the council is where if at all they wanted to make changes in the bill, they can make changes in the bill. And then it goes to the third reading, and in the third reading either they totally accept it or they totally reject it. So once all these stages over, then it may go to the governor or it may not go to the governor. So now let us try to understand, including all those things, what can happen in the second reading house. Then we'll try to understand what are the various possible options in the legislative council or in the second house. Because we have assumed that the bill is introduced in the legislative assembly, now let us assume the second house is nothing but the legislative council. So what happens in the legislative council? What are the things? Try to follow me, and then I'll say what are the various possible options. So first happens in the legislative council is the introduction stage. In the introduction stage, that the major objectives and reasons of this particular bill is also discussed in the legislative council as it has happened in the legislative assembly. After the introduction stage, it directly goes to what is called as a second reading stage. Now what happens in the second reading stage? In the second reading stage, the entire house, that is the legislative council, discuss about the provisions of the bill. So if at all any changes that can happen to the bill, it can happen only in this particular stage. So therefore two things can happen once the bill goes to the second reading stage. What is likely to happen once the bill goes to the second reading stage? Either they can make changes to the bill, that is the legislative council can make changes to the bill. If they make changes to the bill, it will be different from the way that it has been passed to the legislative council. Or they can pass the bill without no changes. They are making no changes in this particular stage. Whether changes or no changes that has happened in the second reading stage, then it goes to the third reading stage. In the third reading stage, it is also called as, what happens in the third reading stage? In the third reading stage, what happens is mainly the bill is totally accepted or rejected. So therefore there are only two outcomes. Either you accept the bill in the third reading stage, or you reject the bill in the third reading stage. Remember, the legislative council has a power to reject the bill also, similar to that of the Rajya Sabha. But however, there are some slight differences. So we'll try to understand them one by one. Okay, these are all the various things that can happen in the second house, that is the legislative council, once a bill is introduced from the assembly to the council. Now let us try to understand one by one. Okay, now the bill is introduced, and after introduction it goes to the second reading stage. Now let us assume that in the second reading stage no changes. So I'm just trying to understand the various possible options. There is no changes. That means whatever the way the bill is introduced in the council from the assembly, the council is not making any changes in the bill. Without any changes, they are accepting it. So let us mark this as 1. So no changes are made, and the legislative council in the third reading stage is accepting it. So therefore one possible option is that the legislative council can accept the bill. If they accept the bill, then it will go for the governor for his assent. It will go for governor's assent. So this is one possible option. Now let us try to understand the second possible option. The second possible option is the bill is introduced in the legislative council, goes for the second reading stage. In the second reading stage, there are no changes. The council is not making any change, but the council can reject it instead of accepting it. So therefore, they can make no changes and they can reject it also. Either they can accept or they can reject. So therefore, what is the other option? That they can reject the bill. If they reject the bill, then the bill cannot go to the governor for his assent. So that is the second option. So here it does not directly go to the governor for assent. So what will happen to this when the bill is rejected? We will try to understand this. So either they can accept the bill or they don't accept the bill. Now what are the other options possible? Introduced in the legislative council from the assembly, goes to the second reading stage. So you have seen that if no changes are made, these two things can happen. But it might also be possible that in the legislative council they are making changes. When they make changes, the version of the bill in the council would be little different from the version of the bill as it was passed from the assembly. So both two versions are not the same if the changes are made. So therefore they can make changes also. So now let us assume this is option number 3. If they make changes and after making changes it goes to the third reading stage. In the third reading stage they can reject it also. So if the whether they make changes or no changes, but if they reject it, then almost the bill is rejected. So that is equivalent to that of this thing. So whenever they reject it, no problem. But let us assume they make changes. After making changes, it comes to the third reading stage where it is accepted by the legislative council. That means the legislative council is accepting the bill in a different form than that the form it is passed from the legislative assembly. Let us assume the legislative assembly is passing the bill with, let us assume 100 sections, but in the legislative council they delete one section. So therefore only 99 sections are approved in the act or in the bill by the legislative council. So therefore the version of the bill passed from the assembly and the version of the bill in the council as it is passed, it is not the same. But however it has been accepted by the legislative council. Now in this case what will happen is the bill cannot go to the governor, because the bill can go to the governor only when the version of the bill is the same in both the houses. So therefore under such a circumstances, if they accept the bill after making changes in the second reading stage, then the bill has to be again sent back to the assembly. From here it has to again go to the legislative assembly. So when it is again sent back to the assembly has two options. The assembly can accept it or the assembly can reject it. That is not accepting it. If the assembly accepts it, no problem, because whatever the changes that is made by the council, and if it is not in the same way as it has been passed by the assembly, from the council it has to be sent to the assembly. If the assembly accept it, then that means both assembly and council are agreeing on a common version of the bill. So then it will go to the president assent. So therefore it is like accepting the bill, no change. But if any changes are made by the council and the changed version of the bill is accepted by the council in the third reading stage and then again sent to the assembly, where the assembly is not accepting it, it is not equivalent to rejection, but let us assume the assembly is not accepting to the amendments. If the assembly is not accepting to the amendments that is made, then that is a different option. So then the third option could be that the amendments which are made by the council and sent back to the assembly, which is not acceptable to the assembly. So this is another option that is possible. So in this case, what is likely to happen? So you understood that whenever a bill is passed from the assembly to the council, the assembly can either accept the council can either accept the bill, the council can reject the bill, or the council can make changes, send it back to the assembly, which is not acceptable to the assembly. And the fourth option that is likely to happen is that the bill is introduced in the legislative council. The first stage is the introduction stage. After the bill is introduced in the council, nothing has happened in the council. After the bill is introduced in the council, for the next 6 months, nothing has happened. That means the council has not taken up the bill for the second reading stage or the third reading stage. It is wherever the bill is introduced, it is pending at that particular stage only, and in that manner 6 months have gone after the introduction of the bill. Then also it is problematic. So there is another option that the council does not take any action for a period of 3 months. Sorry, it is not 6 months, that is only in case of Rajya Sabha, but here it is 3 months. That the council does not take any action for a period of 3 months. That means after the introduction of the bill in the council does not take any action for a period of 3 months. So then also what is likely to happen? Now remember, if they accept the bill, there is no issue. that is the council, if they accept the bill after it is passed by the assembly, no issue. Then the bill goes to the governor and the governor can exercise number of options. But apart from accepting the bill, if either the council rejects the bill or if the council does not take any action for a period of 3 months after the bill is introduced there, or the third thing is that the council, whatever amendments that they have made is not acceptable to the legislative assembly, in all the three cases, then technically the bill cannot move forward to the governor. But however, in case of the state legislature, there is no provision for what is called as a joint sitting. We have already learned in case of the parliament, if there is a deadlock between two houses, then in that particular case there is a provision for joint sitting, where the president can convene a joint sitting and the speaker will preside over the joint sitting, and if the bill is put to vote by a simple majority in the joint sitting, it is deemed to be passed by both the houses of the state legislature. But however, when it comes to the state legislature, there is no provision for what is called as a joint sitting. So what will happen under all these cases? If the bill is rejected by the council, or if the council does not take action for a period of 3 months, or if the amendments are made by the council which is not acceptable to the assembly, in all the three cases what is likely to happen, that the bill will be sent to the legislative council for the second time from the assembly. Now when they send it for the first time, if any of these three things happens, that is whether the council reject the bill or does not take any action for a period of 3 months, or they make amendments and send back to the assembly which is not acceptable to the assembly, if these three things are the outcome when the bill was sent from the assembly to the council for the first time, if any of these three outcomes happens, then the assembly can again send the bill back to the council for the second time. When the assembly sends the bill back to the council for the second time, the maximum time that the council have got is 1 month time. Within 1 month, if they accept it, it is okay. Within 1 month, if they reject it, or if they make amendments and send it again back to the council, or if they do not take any action for a period of 1 month, then the bill is deemed to be passed in the same manner as it is passed by the assembly. So therefore, try to understand, if the bill is passed from the assembly to the council for the first time, and if any of these three outcomes comes, that is option 2, 3 or 4 except option 1, then what the assembly can do is, the assembly can again send the bill back to the council for the second time. Okay, when the assembly sends the bill back to the council for the second time, if they accept the bill within 1 month after it is sent from the assembly to the council for the second time, if the council accepts the bill within 1 time, then the bill is sent to the governor for his assent. If they don't accept, or if they reject the bill within a period of 1 month after it is sent from assembly to the council for the second time, if they reject it, then also the bill is deemed to be passed in the same manner as it is passed by both houses of the state legislature, and it is sent to the governor for his assent. Or if the legislative council does not take any action for a period of 1 month, then also the bill is deemed to be passed in the same manner as it is passed by the council as it is passed by the assembly after it is passed to the council for the second time. So therefore, the maximum power in the hands of the council is that they can delay the passage of the bill when it comes to an ordinary bill by 3 months in the first instance and 1 month in the second instance. So therefore, what is the maximum power in the hands of the legislative council when it comes to an ordinary bill? They do not have equal powers, but they can delay the passage of the bill by 4 months. 3 months in the first instance and 1 month in the second instance. So this is exactly what you'll have to understand with regard to what is called as a procedure for ordinary bill when it comes to the state legislature. Therefore, two important things that you have to keep in your mind. The first thing is, when it comes to the state legislature, there is no provision for deadlock as it happens in the parliament. Second thing is, because there is no provision for deadlock, there is no provision for joint sitting when it comes to the state legislature. In fact, when I was writing my first mains, this question came in the mains examination also, that what if the legislative council does not agree with the assembly when an ordinary bill is to be passed? What are all the options in the hands of the legislative council? So I don't say that such type of questions, I'm not saying such type of questions will come, but probably the idea is that UPSC is giving a lot of importance to this particular area. The student should also know about all those things. And most importantly, the procedure is little different in this particular case as to what happens in parliament and what happens in state legislature. So try to have a proper understanding. And because there is no provision for deadlock in the state legislature, there is no provision for what is called as joint sitting also. So what is the maximum power in the hands of the state legislature? What is the maximum power of the legislative council in a state legislature is that they can delay the passage of a bill by 4 months, 3 months in the first instance and 1 month in the second instance. I hope it is clear to all of you. Now with that we'll go to the next thing, that is what are all the various options in the hands of the governor. Now just don't think about the money bill or the financial bill. Now let us see as to what are the various options in the hands of the governor. Options in hands of the governor. That is, what are the various options in the hands of the governor when it comes to an ordinary bill. So the first thing is the governor can give the assent. If he gives the assent, the bill becomes an act. Or the governor can withhold the assent. Withhold the assent means that he is not giving the assent to the bill, which is similar to that of the absolute veto exercised by the president. But the Supreme Court of India has categorically said that whenever the governor withholds the assent to the bill, it is not his discretionary power. It has to be followed with what is called as sending it for reconsideration. So the third option he can exercise is sending it for reconsideration to the legislature. But whenever he is sending it for reconsideration to the legislature, because the governor is having some problem with the bill, and whenever the bill is again sent back by the legislature by the simple majority or the same majority, then the governor is bound to give the assent. So this is similar to that of the suspensive veto. And the fourth option is the governor can also reserve the bill for the consideration of the president. So once the bill is reserved for the consideration of the president, then the fate of the bill will be decided by the president of India. Therefore, after that, the governor has no power with regard to this particular bill. Only the president is going to decide the fate of this particular bill as per the aid and advice of the Union Council of Ministers. So what are the various options in the hands of the governor according to Article 200 of the Constitution? So these are the various possible options. If the president gives the assent, the bill becomes an act. If the president withholds the assent, he cannot just withhold. If he withholds the assent to the bill, then he should also send it for reconsideration. So withholding the assent to the bill should always be followed by what is called as reconsideration. So that is the second option. But without withholding the bill, he can directly send it for reconsideration. Try to understand that. He can give the assent. If he withholds the assent to the bill, then he has to send it for reconsideration to the legislature. But without withholding the assent to the bill, he can directly send it for reconsideration also. But anyways, either ways, if he is sending the bill for the reconsideration to the legislature, if the bill is again sent back to the governor, then the governor has to give the assent. Or the third thing, the last thing is he can also reserve the bill for the consideration of the president. If he reserves the bill for the consideration of the president, then the fate of the bill is decided by the president on the aid and advice of the Union Council of Ministers. Now these are all the various possible options that the governor can exercise. But however, reserving the bill for the consideration of the president is the discretionary power of the governor. So he can reserve any type of bill, but constitutionally under one circumstances he is mandated to reserve the bill for the consideration of the president. What is the case? He is supposed to reserve the bill for the consideration of the president if any bill derogates the powers of the High Court concerned. That is, if a bill is introduced in the state legislature in such a way that it is trying to take over the powers of the High Court, then in that particular case, the governor has to mandatorily reserve this bill for the consideration of the president, but not in the other cases. So these are all the possible options that the governor can exercise. So the governor can exercise all these four options when it comes to an ordinary bill. We are talking about what is called as an ordinary bill. Alright. So we have understood the entire process of an ordinary bill. So in case of an ordinary bill, try to understand what is the power of the Legislative Assembly and the Legislative Council. There is no equal powers because the will of the Legislative Assembly will prevail over the will of the Legislative Council. Why? Because the maximum power in the hands of the Legislative Council is that they can delay the passage of the bill by 4 months. 3 months in the first instance and 1 month in the second instance. But on the contrary, if the bill is introduced in the Legislative Council and then from the Council it is sent to the Assembly, if the Assembly rejects the bill, and that is the end of the bill. So therefore there is no equal powers between them. And then when it comes to the governor, the governor can exercise all the four options. So this is in case of an ordinary bill, but it is not the only type of bill. We know that apart from the ordinary bill, there can be other types of financial bill also. In fact, money bill is also one type of financial bill. Apart from money bill, what are the other types of financial bills? It is financial bill type 1 and financial bill type 2. So to quickly understand as to what is a money bill in this particular case, a money bill is also a financial bill, but it strictly contains only those financial matters mentioned in Article 199 of the Constitution, which is related to taxation, which is related to borrowings, which is related to appropriation of money from the consolidated fund of the state, receipt of money on account of consolidated fund and the public accounts of India, declaring an expenditure to be a charge expenditure on the consolidated fund of the state. So these are all some subject matters which is mentioned in Article 199 of the Constitution. So that means, therefore, what is a money bill? A money bill is just nothing but a financial bill, but this financial bill contains only those subject matters which is mentioned in Article 199 of the Constitution. So if any financial bill which contains only those subject matters which is mentioned in Article 199 of the Constitution, such financial bills can be certified as a money bill by the Speaker of the Legislative Assembly. So therefore, it becomes what is called as a money bill. Okay, suppose if it is a money bill, then in case of a money bill, how the procedure is little different from that of what is called as an ordinary bill. So how the procedure is little different? There are two things that you have to keep in your mind. First of all, the procedure is different because in case of an ordinary bill, the bill can be introduced in both the houses. Whereas in case of a money bill, where the bill can be introduced, it can be introduced only in the Legislative Assembly. So that's the first difference. So introduction can happen only in the Legislative Assembly, not in the council. That's the first difference in comparison to an ordinary bill. Second is, to introduce a money bill, there is a need for prior recommendation of the governor. So only after taking the prior recommendation of the governor, the bill can be introduced. So these are the two important things that you'll have to keep in your mind. So while this is not the case for an ordinary bill, in case of a money bill, what you should understand? To introduce the bill, it requires a prior recommendation of the governor, and it can be introduced only in what is called as the Legislative Assembly. Now, once a bill is introduced, then it goes through all the stages as we have discussed: introduction stage, second reading, third reading, and then when the bill is put to vote in the Legislative Assembly, then the bill is sent to the council. Now, when a money bill is sent to the council, the speaker certifies this bill as a money bill to the council before it has been sent to the council. So, what are the options in the hands of the council in case of a money bill? The options in the hands of the council in case of a money bill is that they can delay this bill by a maximum of 14 days. What is the maximum power that they have got? That they can delay a bill by a maximum of 14 days. Once a bill is received by the council, within 14 days, they can accept to the bill. If they accept to the bill, it will go for the governor for his assent. If they don't accept to the bill, then they can also make amendments to this particular bill. That means they can suggest certain amendments. So within 14 days, they can accept it. Within 14 days, they can suggest some amendments and send it back to the assembly. That too within 14 days. They can suggest some amendments, send it back to the assembly, but it is not mandatory for the assembly to accept it. If the assembly don't accept these amendments suggested by the council, then the bill is deemed to be passed in the same manner as it is passed by the assembly. The council cannot reject the bill in it comes to what is called as a money bill. So there are three options that they can exercise. Council, what are the options they can exercise? They can accept the bill within 14 days, or they do not take any action for 14 days, or they make some amendments, send it back to the assembly, suggest some amendments to the assembly within 14 days. In all the cases, after 14 days, the bill is deemed to be passed in the same manner as it is passed by the assembly. In one case, when they suggest amendment to the assembly within 14 days, if the assembly accepts to the amendments, it's okay. But if the assembly don't accept to these amendments, then also the bill is deemed to be passed in the same manner as it is passed by the assembly. So therefore, the maximum power in the hands of the council when it comes to a money bill is that they can delay the passage of this particular bill by 14 days. All right. So this is with regard to the money bill. Okay, now it is passed to the governor for his assent. So what are all the options that can be exercised by the governor when the money bill is sent to him? The governor can give the assent to the bill, the governor can withhold the assent to the bill, and the governor can reserve the bill for the consideration of the president, but he cannot return it for the reconsideration. So that is not possible when it comes to what is called as a money bill. So now I am talking about a money bill. So these are all the options that the governor can exercise. Now the next type of bill is the financial bill type 1 and financial bill type 2. Now what is a financial bill type 1? The financial bill type 1 that we are going to discuss is financial bill type 1 is a classic combination of money bill plus ordinary bill. So therefore it will have the procedures of both money bill as well as ordinary bill. In certain respects it is similar to that of money bill, and certain respects it is similar to that of an ordinary bill. But what is the subject matter of a financial bill type 1? The subject matter of the financial bill type 1 is it contains at least one of the matter or some of the matters which is mentioned in article 119, sorry, article 199. If it is containing only those subject matters which is mentioned in article 199, then such financial bills are money bills. But if a financial bill is there, it contains some of the matters which is mentioned in article 199 of the constitution, but it does not solely contain only those things. It is not solely containing only those things. It contains certain other subject matters as well. So article 199 plus certain other subject matters. Certain other subject matters. Then in that particular case, then the bill would be considered to be what is called as a financial bill type 1. So what is a financial bill type 1? A financial bill type 1 is something which contains some of the subject matters mentioned in article 119, but some of the subject matters outside the scope of article 119. Now in that particular case, such a type of bill would be considered to be financial bill type 1. So what is the procedure for a financial bill type 1? The procedure for a financial bill type 1 is similar to that of the money bill in certain respects and similar to that of the ordinary bill in certain other respects. To what extent it is similar to that of a money bill? It is similar to that of a money bill in two respects, that is, it can be introduced only with a prior recommendation of the governor and it can be introduced only in the legislative assembly. So therefore a financial bill type 1 can also not be introduced in what is called as the legislative council. It can be introduced only in the legislative assembly with the prior recommendation of the governor. In all other cases, it is similar to that of an ordinary bill. So when I say in all other respects, it is similar to that of an ordinary bill, that means what shall be the options in the hands of the council after it is passed from the assembly to the council? The council can accept it, the council can reject it, the council can not delay it without taking any action for 3 months, or the council may amend it and send it back to the assembly, which may not be acceptable to the assembly. In all these cases, except when the council accepts the bill in the same manner as it is passed by the assembly, in all other cases, the assembly can again send the bill back to the council, and when it is sending the bill back to the council for the second time, the council can maximum delay it by a maximum of 1 month. So therefore, try to understand that except for these two areas, that is a financial bill type 1 can be introduced only in the assembly and with a prior recommendation of the governor. In all other respects, it is similar to that of an ordinary bill. So therefore, the legislative council will have all the powers it exercises in case of an ordinary bill when it comes to a financial bill type 1. So to summarize, what is the power in the hands of the legislative council when it comes to a financial bill type 1? That the legislative council can delay the passage of a financial bill type 1 by a maximum of 4 months. 3 months in the first instance and 1 month in the second instance. Okay, after it is passed by both the houses, then it comes to the governor for his assent. So when the financial bill type 1 is presented to the governor for his assent, then in that particular case, what are the options that can be exercised by the governor? The governor can exercise all the options that he can exercise for an ordinary bill. That means he can give the assent, he can withhold the assent. If he withholds the assent, then he has to send it for reconsideration, or separately he can send it for reconsideration. Either ways, whenever the bill is sent for the reconsideration, if the bill is again sent back by the legislature, then the governor has to give the assent, or the governor can reserve the bill for the consideration of the president. So these are all the various options when it comes to financial bill type 1. Now let us try to study about what is called as the financial bill type 2. So what are all the various powers in the hands of the legislative council, or the procedure in case of financial bill type 2, and the options in the hands of the governor. Now what is a financial bill type 2? It is also a financial bill, but it does not contain any of the matter which is mentioned in article 199. It does not contain any matter which is mentioned in article 199, but it does involve certain expenditure to the government. Then in that particular case, it is called as financial bill type 2. A financial bill type 2 is similar to that of an ordinary bill in all the respects. You don't have to have anything different, it is similar to that of an ordinary bill that we have discussed in all the respects except one difference. What is the difference? In a ordinary bill, the bill is introduced in the either of the houses. It can be introduced either in the legislative assembly or the council, but after it is introduced, then it automatically goes to the next stage. That is, it goes to the referral to the DRSEs or appropriate parliamentary committees and to the other stages. But whereas in case of a financial bill type 2, in case of a financial bill type 2 also, it can be introduced in either houses. It can be introduced in the Lok Sabha, legislative assembly or the council. It does not require any prior recommendation of the governor. So all these things are similar to that of an ordinary bill. But however, after the bill is introduced, and after the introduction stage, for the bill to go to the next stage, that is referral to the various parliamentary committees or to go to the second reading stage, that is to move from the first stage to the second stage, there is a need for the recommendation of the governor. So it is not equivalent to that of the prior recommendation. When I say prior recommendation for the introduction, the bill can be introduced only with the recommendation of the governor. So the prior recommendation is not required. But after the bill is introduced, for the bill to move from the introduction stage to the next stage, the governor has to recommend for it. In fact, the governor has to make this recommendation in both the houses. That is in the legislative assembly also, in the council also, once it is introduced in that particular house. So this is basically the only difference between a financial bill type 2 and that of what is called as an ordinary bill. Now try to understand, in all other respects, a financial bill type 2 is similar to that of an ordinary bill. That means it can be introduced in either houses, and then what is the power in the hands of the legislative council? The legislative council can accept it, they can reject it, they may not take any action for 3 months, or they can make amendments, send it back to the assembly, which is not acceptable to the assembly. In these cases, that is, if the legislative council does not accept it, that is, they reject it, or they make changes and send it back to the assembly, which is not acceptable to the assembly, or they reject it. In all the 3 cases, the assembly can send the financial bill type 2 again back to the council. And when the bill is sent back to the council for the second time, the council can maximum delay the bill by a passage of 1 month. So therefore, the maximum power in the hands of the council when it comes to the financial bill type 2 is also, they can delay the passage of the bill by 4 months, similar to that of an ordinary bill, that is 3 months in the first instance and 1 month in the second instance. This is the maximum power they have got. So it should be quite clear to all of you as to what is the power of the legislative council when it comes to financial bill type 2. Now finally, what are all the various options in the hands of the legislative council? Sorry, what are the various options in the hands of the governor? I said that the financial bill type 2 is almost similar to that of an ordinary bill, except for the recommendation of the president is, recommendation of the governor after the introduction is required. That means whenever the bill goes to the governor, the financial bill type 2, in case of financial bill type 2, the governor will exercise all the options as that of an ordinary bill. That means he can give the assent, he can withhold the assent. If he withhold, he has to send it for reconsideration, or separately he can send it for reconsideration. In both the cases, after reconsideration, when it comes to the governor has to give the assent. Or the last thing is, he can also reserve the bill for the consideration of the president. So these are the various options that can be exercised by the governor in case of what is called as a financial bill type 2. So I'm quite sure conceptually it is all clear to you as to what are the different types of bills when it comes to the state legislature. What is a procedure for a ordinary bill? What is a procedure for a money bill? What is a procedure for a financial bill type 1? What is a procedure for a financial bill type 2? How they are different from one another in terms of their procedure, in terms of their subject matter, and also what are the various options that can be exercised by the governor when such a bills are presented for his assent. These things are very, very important and can be asked in the examination. All right. So almost we have come to the last part of our discussion. So the last part of the discussion is, so therefore, what is the power of the council vis-a-vis the assembly? So definitely in case of the states, the council and the assembly are not having equal powers. More powers are given to the assembly. So let us try to understand as to what are the powers of the council vis-a-vis the assembly, where they have an equal status, where they have an unequal status. Selection of ministers, equal status. When I say equal status, that the members of the council and the members of the legislative assembly, any of them can be appointed as a minister. So with regard to the appointment of ministers, they have equal status or equal powers. Consideration of various reports, whatever the report that the governor may submit, the governor may submit the report of the finance commission, the governor may submit the report of the comptroller and auditor general. In all these cases, both the houses or the members in both the houses can scrutinize these reports. So therefore, there is equal powers. Introduction of ordinary bill. An ordinary bill can be introduced either in the Lok Sabha or in the either in the Legislative Assembly or in the Council. So therefore, in these cases you can say equal powers. But however, in certain respects there are unequal powers. What are the powers? Unequal powers. In case of a money bill, because in case of a money bill it can be introduced only in the Assembly, not in the Council. And also the Council can delay it only by 14 days. So unequal power. Passage of ordinary bills. Although the bills can be introduced, but ultimately, what is the power of the council when it comes to an ordinary bill? That they can delay the passage of the bill by 4 months, nothing more than that. So therefore, in this regard also they have unequal powers. Vote on demand for grants. Vote on demand for grants is part of the budget. Remember, we have discussed the budget in case of the union legislature. The process of enacting the budget in the state legislature is also the same, no difference. And we have seen that in the process of enactment of the budget, there is one stage which is called as vote on demand for grants. The vote on demand for grants in the union budgetary process is only the prerogative of the Lok Sabha. So similarly here, in case of the states, the vote on demand for grants is only the prerogative of the Legislative Assembly and not the Council. Electoral College of the President, who is taking part in the President election? It includes the members of the Parliament and also the members of the State Legislative Assembly in the states and not of the Council. So even if a state is having the Council, the members of the Legislative Council are not part of the Electoral College. So therefore, there is no equal power in this regard. So these are all the areas where there is unequal status. And then ratification of a constitutional amendment bill. Remember, whenever a constitutional amendment is introduced, and if that amendment is trying to amend the federal provisions of the Constitution, I have categorically said that amendment is not only to be passed by special majority in both the houses of the Parliament. After it is passed by special majority in both houses of the Parliament, it is also sent for the ratification by various state legislature. And when it is sent for the ratification to the various state legislature, not less than half of the state legislatures have to ratify them. And when they are sent to the state legislature, if any state is having both Legislative Assembly and the Council, it has to be sent to both the Legislative Assembly and the Council also. And in fact, both the houses have to ratify them. Suppose if the Council is not agreeing with that, so how long the Council can delay it? The Council can maximum delay it by 4 months. At the end of 4 months, the will of the Assembly will prevail over the Council, even in case of a constitutional amendment bill. So therefore, here also there is no equal powers. And in fact, if you look into the Constitution clearly, the very existence of the Council depends upon the Assembly. Because the creation and abolition of the Legislative Council depends upon the resolution that is passed by the concerned legislature or the state legislative assembly of that particular state. So in all these cases, there are unequal status. So try to remember what are all the areas where there is equal status and what are all the areas where there is unequal status. So now I am sure that you might have a very fair idea as to how the law is enacted in the state legislature, the different types of bills in the state legislature, how the procedure is different for the different types of bills, and of course what are all the different options that the governor can exercise for all these bills, and also in which are all the areas there is an equal status and what are all the areas there is an unequal status. So I am very sure that this particular lecture will give a lot of conceptual clarity. So every lecture what we will do is we will try to give a lot of conceptual clarity to the students, because the biggest problem with the students is they end up making mistakes assuming that the subjects are easy is because of a smaller lack of clarity in certain areas. So we'll try to plug all those gaps in your understanding. With that, we are coming to the end of the discussion. Try to answer this particular question. Consider the following statements. Statement 1, the will of the assembly prevails over the will of the council in case of passage of the ordinary bills in the state legislature. Is that statement true or false? Statement 2, both legislative assembly and the council have equal status in case of appointment of ministers. Is it true or false? Which of the statements given above are correct? Option A, 1 only, option B, 2 only, both 1 and 2, neither 1 nor 2. So if you know the answer, please put it in the comment box, and if you have any queries also, you can put it in the comment box, and whatever you wanted to convey to me, you can put it in the comment box, because your comments are very important to me. Your comments are going to motivate me to make further videos. Alright, and also please like this video if you like this particular lecture, and also share it with your friends and others who are preparing for the examination. It will immensely benefit the students preparing for the competitive examination, including the UPSC examination. If you have any other queries, you can reach out to me. Don't hesitate to reach out to me. You can consider me as your friend, mentor, guide, whatever it is. Do reach out to me in case of any queries. Thank you very much for watching this particular lecture. All the best.